Attested will, we're going to talk briefly about that. That's a will you typically think of that's written, typewritten, word processed, and it's signed. Sometimes they're in blue folders. You usually get those from an attorney. They're notarized, they have witnesses, all that fun stuff, right? So those are, folks tend to think of those as being official wills. But Tennessee also recognizes what's called a holographic will, which is a will that's written on a piece of paper. I don't have a piece of paper, but I do have a pen. Entirely in that person's handwriting, and it's signed and dated, and that is also considered a valid will in the state of Tennessee. Okay, so just keep that in mind. Don't have to have it notarized, you don't have to have it witnessed. It has to be entirely in my handwriting if I'm doing this, right? And it has to be signed, and I need to date that, and that can be considered a will. Does it mean that there will be no contest or people disputing it after you pass away? No, that does not mean that, right? You can go to the highest priced attorney in whichever city you pick, and there could always be someone who has a problem with what a will says and can contest it, right? It doesn't mean they're going to succeed, but they can make things complicated. So attested or holographic wills can both be contested and both be disputed if someone disagrees with it. Questions there? Another question I see a lot is, I moved to Tennessee from Illinois. Can I use my Illinois will? And Tennessee does have a provision to recognize the wills and legal documents of other states, as long as they're substantially in compliance with that state law from the state that you moved from. And a lot of us in Tennessee are like, we're licensed to practice law in the state of Tennessee. I can't tell you what Illinois says about what's substantial compliance with the state of Illinois laws on wills. So my recommendation is, just for ease, once you have to probate everything or turn a will in for the probate process, is probably just go ahead and get a will in the state in which you're living at that time. So if you move from Illinois to Tennessee, I'd go to a Tennessee licensed attorney and get that will done, or write one out by hand. Questions there? Yes, ma'am. And then yes, sir. That's okay. Okay. Yeah. So I would go to a Texas attorney and have them look at it. I don't know what the laws of Texas are. Texas may say that Tennessee will is great and you are good to go. But I would just consult a licensed attorney in that area just to check on that for you, right? And take a look at it. You're welcome. Yes, sir.
Let's say I went to an attorney
Yes.
here in Tennessee, and I paid $500
Right.
to have my will paid off. And now after, say, 10 years, I want to make a change. Can I do a photograph to attach to that will, or do I have to go back and have an attorney? In other words, if I have a written will, can I do a holograph?
So I'm a licensed attorney, right? So my suggestion is, if you have an attested will, I would always go back, if you want to change that, is go back to an attorney or a legal aid or a TALS to get that modified. These are like standalone. Like the attested one is attested. Like it's notarized. It has specific things that it has to include to be valid. If you start scratching on it, you know what I'm saying? Even if you sign it, then the question comes up, did you actually do that, or did a bad actor actually do that, right? And the questions come up there. So my suggestion is always, always, always go ahead and get it redone. You can revoke a will as long as you have capacity. And capacity means I understand what I'm doing, right, at that moment in time and at that time period. So you could say, you could write, if you had an attested will and you wanted to change it like right then, you could do a holographic will and say, this is my last will and testament, and it cancels out any other previous wills and testaments. I may not want to rely on that, but if it was an immediate pressing circumstance, I could see folks doing that. You're welcome. I know, I hate to say go see an attorney. I do understand. It's awful. Sorry. But I would do that before I would start like hand marking things off on an attested will or testament. Okay. Anything else here? Any other questions? So the will, TALS has been working with the legal aids and working with the Indeed project out of UTC Chattanooga, and we've been doing clinics where we're providing wills, powers of attorney, and advanced care directives to individuals 60 and over at no charge. The only thing I'm going to say is they are simple wills, right? If you own property in Tennessee and also Florida, that is beyond the scope of what we will do and can do. So we would send you on to a private practice lawyer. But we do and can do straightforward, simple wills, simple powers of attorney, and advanced care plans. They're always pretty straightforward. And we can talk to the church and your minister if you guys would like us to come back. We can always do that. We have one information session where we talk to everyone about the documents that we offer, and we get everybody to sign up. And then we come back later. We send out a link, and you answer a questionnaire, and it uploads to our software. And then we come back and execute the documents a couple weeks later. Another question I always get is wills versus trusts. If you are wanting a trust, that is not something that TALS or any of the legal aids in the state of Tennessee, and there are 4 of them, are going to do or be able to do, right? A trust is a complicated vehicle for the inheritance of stuff, and it is a great vehicle for certain people, and it's not a good vehicle for other people, right? Some people would be better served by a will, some people would be better served by a trust, and that's something where we always suggest folks go to a private attorney and talk to them. Trusts can be complicated. You have to retitle property, you have to title it a certain way, you have to populate the trust, and if you don't do everything properly, you're kind of worse off shape than if you had nothing, right? If you had no trust. So it can be done. I've seen it done very successfully. Trusts can be great. But there are a lot of steps that have to be followed after you and the attorney are finished setting up the trust. So a lot of people do that for inheritance tax reasons. Sometimes it can be useful when thinking about eligibility for Medicaid. Sometimes not. One quick thing I do want to say about houses, since we're talking about wills, and some people always ask, can I just quit claim deed my home to my children, and that way that property is already titled over to them, and I don't have to worry about a will or going through probate to change a title, because that's one of the reasons we go through probate, right? Yes, you can, but just know, for the purposes of qualifying for Medicaid, there is a 5-year look-back period. When I was at the state, I always said at least 5 years to be safe. I always if you can err on that 6-year side, that's even better, right? Because the state of Tennessee will look at assets that you had and how you disposed of them within that look back period. And a house is excluded, your personal home, when qualifying for Medicaid, but if you give it away, you could have sold it for fair market value, right? A couple $100,000, and use those funds to support your care and care needs during that time. So just keep that in mind. That's where we see a lot of folks get tripped up when they're talking about houses and Medicaid qualification. All right, any other questions there? So 5 years at least a look back. The state's going to look back and see what kind of assets you had access to. I had a person at one of my recent events ask, well, what if I just sell my house? That's what I'm going to do. I don't want a will. I don't want to do anything. I'm going to sell my house and I'm going to put the money in the bank. It's that is great. You can absolutely do that. Just know, though, if you're trying to qualify for Medicaid, which in Tennessee is called TennCare Choices, that pays for long-term services and supports, the state is going to look back for those 5 years, and if they see you sold a house for that $200,000, they're going to ask questions about where that money went, okay, and why or why not was it used to support you and your healthcare needs. So just keep that in mind. That is one way to do it. If you keep it as a house, if it's your house, it's excluded. But once it's liquidated or given away or anything else happens to it, then questions start arising when we're talking about Medicaid qualification. Okay, and that's a very simplification of something that's super complicated, and the rules seem to change every day. Also get questions about what is a state recovery. If I have a house and I have a will and I'm giving my house to my children, what is this thing called a state recovery? If I need long-term services and supports and I qualify for Medicaid, the state can then put a lien essentially on my house as we go through the probate process and try to recoup some of the money that was used for my care. Okay? Just know that that is a possibility. Does it happen in every situation? No, it does not. I cannot tell you the actual rhyme or reason to when a state recovery actually occurs in Tennessee. It seems to be kind of random. They're supposed to follow a process, but I've seen it happen in estates that were really tiny. And then I've seen it not happen when states were larger. So I couldn't tell you what the rhyme or reason is, but just know that if you happen to be on choices at the end of your life, that the state could participate in something called a state recovery to try and recoup some of those funds. Powers of attorney, let's talk about powers of attorney briefly. Time is going by very quickly. There are two powers of attorney in the state of Tennessee. One is for healthcare and one is for finances, right? I'm going to kind of simplify things a lot. What these documents do is they allow someone else, called an attorney in fact, to step in and make decisions on behalf of me, the principal. Okay? Say I cannot make my own financial decisions. I have a power of attorney for finances that lets a person I choose, my choice, attorney in fact, step in and make those decisions on my behalf. And those decisions have to be made in good faith to the benefit of me, right? So the attorney in fact that I appoint has a fiduciary duty to act in good faith and only in my best interest as the principal. So I always get questions about, but isn't that letting somebody else make decisions for you? It's like, yes it is, but they do have a legal duty to only act in my best interest, okay? That same duty applies to the power of attorney for healthcare. So in Tennessee, those documents are split, and we have two documents, one for finances, one for healthcare. The power of attorney for healthcare allows someone that I pick, called my attorney in fact. I pick that person, I choose that person to make healthcare decisions on my behalf at the time I sign the document or at some other time. There's a difference. You can set it up to where if I become incapacitated, that person could then make those decisions on my behalf. But as long as I have capacity, I'm good to go, and I can make my own decisions. Okay, there's several ways to set that up. Capacity is something we've talked about. What that means, again, is I understand as the principal that I am giving someone else, my attorney in fact, the ability to make decisions for me, either financial or healthcare, and I understand that I'm giving those rights away. If I don't understand that, I'm said to lack capacity, and I cannot enter into powers of attorney. I cannot execute them. I cannot draft them or draw them up. What we see all the time is we will see an adult child come to us and say, I need to get a power of attorney for finances for my mom. And we're like, okay, so I see you, but where's your mom? Oh, she's in a nursing home. Like, that's wonderful, but she has to be the one to initiate that process and to ask for those documents. We do not give adult children or even encourage or help or in any way abet adult children who are trying to get powers of attorney for finances or healthcare or anything, right, for their parents who may not be there. The parent would be our client, and that's who we would talk to. And if I, as an attorney, don't believe that the parent has capacity, none of those documents are getting executed at all, period, end of discussion. And how we judge capacity is a little bit loose. The nurses may want to plug their ears, but a lot of times we'll just ask 3 questions. Like I might go into a conversation with someone who's in their 80s. I'm like, okay, I'm going to ask you ask you 2 questions and tell you one thing, and I want you to remember those and tell them back to me 5 or 10 minutes later. So I might ask them what the day is, like the day, the month, and the year, who the president is, and I might ask them to remember the color red. And we'll keep going with our conversation, and then I might come back. I'll come back 5 or 10 minutes later. I'm like, okay, remember those things I asked you? What did I ask you? And I will ask them to repeat those back to me. Is it foolproof? No. But it's a good way for me to kind of get a sense of, can they remember what I told them? Do they know where they're at? Do they know what's kind of going on in the world? Because, right, you need to, if you know the day, if you know the president, and you remember the color that I asked you to remember, that gives me some insight as an attorney that you're situated, you understand where you're at, you understand a little bit about what's going on. And then also as we continue the conversation, right, I don't ever get all of the information and execute the documents at one time. It's usually 2 meetings, and that gives me a lot of opportunity to talk to the individual, and I am sure that they understand what they're doing and understand what's going on. And never in the presence of the adult children. So we always meet with the client, which is the parent in the situation, the hypothetical I'm using here, separately. The adult children cannot be in the room. Even if the parent wants them in the room, can I say I've ever had a meeting with the adult child in the room? No, I haven't. I've always excluded them, and we've eventually got them to get out. So that can be undue influence and raise all kinds of questions. Yep. So any questions there? But it never fails. I had 3 people on Monday, so we're doing a clinic. I was actually in Memphis on Monday at McWhorter Senior Center with Memphis Area Legal Services doing a clinic, and 3 different people. Well, I need a will from my mom. It's like, but where's your mom? Well, she's at home. Like, she has to be here. I have to talk to her. Like, we cannot do this. So, and then the other two wanted powers of attorney. So it's a no-go. It can't happen. We have to, the individual, the principal has to be there and has to understand what they're doing. So that's the process. So who can execute? Those with capacity and over 18. Types of attorney, we've talked about that, the financial and then the healthcare. And then a question we always get is, I think I go, can you advance it one? The advance directive. Like in the advance directive, you can pick your attorney, in fact, to make decisions for you when you can no longer make them around end-of-life care, right? So what I always tell folks is what the difference, how I think of the difference between the power of attorney and that advance directive or that advanced care plan is the power of attorney for healthcare is a broader document, right? It can be drafted to allow, say, I pick my mother-in-law to be my attorney, in fact, under my healthcare power of attorney. She could get my medical records. She could talk to doctors for me. You know, there's a whole bunch of other things that healthcare power of attorney gives that attorney, in fact, the ability to do that are not always granted, that are not granted under that advanced care plan. Okay, that advanced directive. So it's much broader. It can be drafted to give that attorney, in fact, more things that they can do, more responsibilities. So an advanced directive is going to set out what I want to happen with my care when I can't make those decisions, and those are usually surrounding end of life. End of life care can mean many different things. I am not a medical person at all, so I would refer you back to Dr. Wick on those specific medical things. I'm just the attorney. But what we do is we set them up so when I can't communicate what I want, like if I'm at the end stage of my life and I can't say, I want all the CPR and I want the feeding tube, or conversely, I can say, I don't want any of that. I've set my wishes out when I'm sitting here today and I have capacity. I've set that out in a document that can then be reviewed by the medical care providers and they can follow. Okay? And like I said, for specifics on the medical aspect, I refer you to the medical people. Lawyers are usually frustrated doctors. We couldn't do math, so we didn't go to medical school. So we went to law school instead. Yes, ma'am. I'm not a huge New Year's resolution person for some reason, but I love July 1st because to me, that's like the middle of the year, so I have the whole rest of the year to do these goals and stuff that I set for myself. So that's when my family does all of our document review, right? We look at the retirement accounts. We look at all of these things on July 1st. So July 1st of every year is our review day. So pick a day, right? And do it even every year. I know that seems a little over much, but it does keep it top of mind. And if you need to change something, you're like, oh, yep, I need to. That attorney, in fact, has moved to China. You know what I'm saying? Like, that's probably might need to look at another one to make healthcare decisions for me. So, great point, Dr. Wick. Thank you. We made arrangements for the attorney at that legal aid to go to the facility and speak with that parent on the parent's own, and we set up the appointment directly with the parent, and the adult child was not involved at all and would never be involved. Yes, and when working with the legal aids, they all make house calls too, because we do have some elders that are homebound, and we do realize that. On Monday, we set up one appointment to go to a facility and one appointment to go to a home. So, not a problem, and we try to make all accommodations that we possibly can. So, I'm an attorney, right? So I love forms, and I like forms that are really well recognized, because the last thing we want to do is get in a medical emergency type of situation, right? No one wants to be in that situation. But if you use the form that's put out, and you can see here by the Tennessee Department of Health, that is a form that the medical care providers in the state of Tennessee are very familiar with. They have seen that before. If we're giving them other forms that they may not recognize, and they would probably recognize that 5 wishes form, in a situation of crisis, they may decide, I don't recognize this, I don't know if it's sufficient, I don't know what this is, therefore I'm just going to go ahead and go forward with the medical treatment that I think that should be done. That's a possibility. I've actually seen that happen. So that's why we always recommend that folks go to the Tennessee Department of Health and get that advanced care plan from the website. There's printouts available. It's a 1-page front and back form, and every doctor in the state of Tennessee should be very familiar with that form. So there is some familiarity in those forms. They know they're legally sufficient. They know that the Department of Health has seen them, and they have some comfort in relying on them, particularly if you have family members or the advanced care plan says don't provide, treatment or something like that, right? Because it could potentially put the medical care provider in a situation of liability too. So that's always one thing. I used to represent doctors, sorry. And that's what our doctors would always tell us, is like, we don't know what these things are. So that's why we always, if you go use this form, it is a form that they should have seen before. Let's put it by the Department of Health. Anything else to add there, Dr. Wick? Okay. The advanced care plan is really cool, and this is the top of it. You can kind of see it's very official and formal and all those fun things that our Department of Health loves and our doctors like to see. And, you pick out your attorney, in fact, to make healthcare decisions for you. You can pick an alternate as you want to as well. The great thing about this form is it can be witnessed by 2 adult individuals or notarized. It doesn't have to be notarized. So that's a really cool thing about this form. What I tell folks to do, once you execute this, make sure you give it to your primary healthcare provider. And then also, you can scan it into your phone and email it to yourself. That is one way to keep it, because we don't have a central repository in Tennessee for advanced care plans or advanced directives. So you can email it to yourself, and if you're like me, I probably have, 42,000 emails somewhere in there. In other words, I never delete my emails, right? So you could always pull it up, or a loved one can pull it up on your phone if you're in a situation where you may not have access to that piece of paper. One quick caveat about advanced care plans, because this comes up all the time too. These are not instructive for emergency medical personnel. Okay? Emergency medical personnel will get you stabilized and send you to the healthcare facility. At the healthcare facility, that attending physician will be the one who gets this document and starts following it. Okay? So we always usually get questions about, but they did CPR. EMS did CPR. EMS will do CPR. They will not follow if your advanced directive says no CPR. EMS will still do CPR, get you stabilized if they can, and they get you to the medical care facility where the doctor, the attending, will pick up and review your wishes in the advanced care plan. Okay? All right. I know it's getting very late. Conservatorship, why we do all of these things and why we have durable powers of attorney for finances and healthcare is because if we do not have them in place, and I'm not able to make my own decisions, the only other recourse we have is the legal recourse of conservatorship, right? If I'm in a long-term care facility, I can't make my own decisions, and I never appointed an attorney in fact to make healthcare decisions or financial decisions for me. The only other thing we have left to do is conservatorship, which is a lengthy and expensive legal process. And it takes a long time, and it strips all the rights away from an individual. It's a court process, right? In most cases, and gives them to someone that the court picks or someone else picks, right? It takes away all of my choice. I don't get to pick that person. I don't have capacity to pick that person. So this is why I always put conservatorship up there. It is a tool, and it is a very valuable tool in some situations, right? It's not always a bad thing. But if you have capacity and you have the ability to do those powers of attorney, that advanced care plan, please do them so that those attorneys, in fact, are identified and ready to go, and we don't have to go through this. Okay? All right. Scams and frauds, I said I would give you some resources as well. And here are some websites that I always recommend to folks when they try to ask me about, I got called and they said I was going to get arrested because I didn't go to jury duty. Total scam. You're not going to be arrested because you didn't go to jury duty. But these websites, the Consumer Financial Protection Bureau, that's federal. AARP Tennessee is here in Tennessee. AgeWell is in Tennessee. And then the Tennessee Attorney General's office. They all keep their websites fairly updated. So I always recommend that folks look at their websites if they have any questions about something that might be a scam or a fraud. Okay? And then also don't answer your phone. If it says potential spam, don't answer it. Please. Please, please, please. That is the easiest thing I can tell folks how to avoid scams and fraud is if you don't recognize the number, just don't answer the phone. If it's your doctor, they really will leave a voicemail message. If they don't leave a voicemail message, pretty good indication they were a scammer or a fraudster. All right. legal assistance, you are always welcome to contact the Tennessee Alliance for Legal Services. There's our helpline. We run a helpline that operates every day of the week. We have 4 part-time attorneys, 2 branches of our helpline, one for those 60 and over and one for under 60. Anybody across the state of Tennessee can call us if they have a legal question. We will answer civil legal questions. We can't answer anything on the criminal side just because of our funding. But civil legal questions, give us a call. If someone needs more extensive legal service than we can provide over the phone, we will help them get to a legal aid or another attorney that can help them. We talk to probably over between 5,000 and 6,000 Tennesseans every single year on this helpline. So if you think about it, that's a lot of calls by 4 part-time attorneys, right? So they're talking to folks all day, every day. I have attorneys who were federal court clerks, one who was a big law partner in California for 30 years. You know, we have a huge breadth of knowledge and experience on our helpline, and they're just great folks. Some of them work remotely and some of them work in our office, but you're always encouraged to seek them out. If you need, and you can go to the next one, yes, helpfortn.org. I always refer people to that website. That is done by TALS as well. And we have a lot of blog posts and brochures and just general information about common legal questions and common legal topics. You can see right here, right on our homepage, we have renters and homeowners. We get lots of questions about renting. Divorce, we get lots and lots of questions about divorce and family and custody, and then senior resources as well. Next slide, please. Here's just a couple of the resources that I picked up. Protecting your home from repair, scams, and frauds, renters' rights, how to help folks with utilities, and then representing yourself in General Sessions Court. We do have a lot of clients who do end up in General Sessions Court, and we have a step-by-step brochure that we give folks that helps them through that process if they have questions. Next slide. Tennessee Free Legal Answers, I would be remiss if I didn't mention that. It is an online portal that you can go to at 3 o'clock in the morning if you have a civil legal question. We do ask a couple of questions. On the helpline, we never ask about income. We never sell anything. None of our services are ever for sale, and neither is Tennessee Free Legal Answers, but it's a program with the American Bar Association. So we do ask one question about income. It's very straightforward. You'll see it when you get there, and then you can ask your question. Volunteers will review the question. Attorneys will. They will draft a legal advice letter to you and email it back to you. So this is open 24/7. If you have that question at 3 o'clock in the morning, send it on. The legal aid organizations in Tennessee, I've just put them all on this slide. I think they distribute these slides after the fact, so you will have this as well. Legal Aid of East Tennessee, Middle Tennessee, West Tennessee, and Memphis Area Legal Services is the organization that serves where we're at right now. Any other questions? Awesome. Well, thank you so very much.